So welcome to the 5th in our 16 webinar series, Contemporary Challenges in American and Global Law. I'm Leah Wortham, Professor Emerita of Law at the Columbus School of Law of the Catholic University of America. I'm the Catholic University Director of the American Law Program and LL.M program, in which Catholic University has cooperated with Jagiellonian University in Krakow, Poland for many years. I will be your moderator. Louise Leiden, our Executive Director of Development and Alumni Relations for the Columbus School of Law of the Catholic University of America, will bring greetings from our law school.
Louise, can you unmute yourself?
You're unmuted. You're muted, Louise.
I'm so sorry. I'm usually the one telling everybody else that. So thank you, Professor Wortham. It's a pleasure to be here with all of you. I want to applaud Professor Wortham's leadership from our end in putting this together today and the entire program. I really want to recognize her efforts to foster and cultivate the relationship with the best law school in Poland at Jagiellonian University. It's an honor to work with someone so knowledgeable about the law, but who is also a genuine friendly people person. She's built on deep roots established by our founder of the Catholic Jagiellonian relationship, Emeritus Professor Rhett Ludakowski, who many of you know. Catholic law values this almost 30-year relationship now and partnership with Jagiellonian University. The International Business and Trade Summer Law Program, the American Law Program, and the LL.M in American Law now have more than 2,000 US, Polish, and other international alumni, and we welcome everyone here today who's with us today. Today, the panelists are outstanding, and my hope is that through these Zoom meetings, we may grow our community and create even stronger ties with and among all of our alumni and continue the dialogue with our shared global experience the Catholic University and Jagiellonian programs have fostered. So thank you again for being here with us. I want you to know how much we value your participation and that we look forward to seeing you more often. So stay well, and back to you, Professor.
Thank you. I now turn to Wojciech Banchik, who is the coordinator of the American Law School, and he will welcome on behalf of Jagiellonian University.
Thank you very much, Professor Wortham, for these nice introductory words. Dear participants of the series of webinars, it's a great pleasure for me to express on behalf of the Jagiellonian University, firstly, the great pleasure that we enjoy that you all joined us in the online meeting, showing your interest in the contemporary challenges in American and global law. You've been showing this interest for many meetings already now, and I hope that we will keep meeting for the next meetings as well. Also, this position allows me to present the gratitude to all the persons without whom it will never be possible for this event to happen. It's a source of great pride for the Jagiellonian University to co-organize such an interesting event with the Catholic University of America. The event, which for 4 months keeps gathering as huge audience as nearly 200 before each meeting. Also, that's the event which proves that JU and Catholic University and the Catholic University of America continue initiatives of cooperation throughout many years, and that fruitful cooperation between the two universities continues despite difficult pandemic situation. Given current difficulties, it is certainly not possible that to use the traditional way in which the joint programs used to be held. This is why we decided to develop a new initiative, so that in the absence of traditional insight meetings, we could still offer a new way to learn and to meet together, also taking advantage of the new technological possibilities that have become more and more popular. However, we still hope that sooner or later we will all meet in person during our programs or alumni events. Thank you very much.
So we're delighted to have so many of you with us, 128 at the moment, even as the busy holiday season has begun. We have one more webinar before the holiday break, also on law and technology, That's a week from today, the exact same time next week, December 9th, on intellectual property issues in artificial intelligence with Professor Megan LaBelle, who is co-director of CUA's Law and Technology Institute, and with, as a commenter, International Business and Trade Summer Law Program alum, Titus Sitovsky, who has worked extensively in the field, both legally and as an investor himself. The information on the winter series will be on the website shortly. This series brings a fascinating array of topics, including the differing approaches that the Biden administration is likely to take on international law issues, how well the post-2008 financial crisis infrastructure is likely to hold up to the pandemic's challenges, parallels in the process, politics, and policy of European Union and United States budget making in a COVID-challenged world, and application of COVID to force majeure clauses in commercial contracts. The holidays are a wonderful time to think back about our memories of classmates and other friends when we used to see them in person, and perhaps even think about how to connect with them in a lockdown world. Consider reaching out to classmates and colleagues about connecting in these webinars. Perhaps you could organize watching a webinar together and then having your own discussion session online about the issues after. So Gaspar, I think Luke is going to post the URL for the series. This webinar series is a team effort as described, starting with the strong support from the deans of the two institutions, whom we thank very much. They are possible by the hard work, particularly of the Foreign Law School Center at Jagiellonian, known as OXPO, and our CUA Development and Alumni Office, as well as our LL.M coordinators. The format today differs from the previous 4 webinars. Justyna Regan and Doug Bonner have joined forces as co-speakers, rather than the speaker and commenter format we have used before. Their topic is data privacy in the United States, where we stand today and predictions for the future. Most people on this webinar are aware of the dramatic impact the European Union General Data Protection Regulation, the infamous GDPR, had not only in Europe, but in the United States. Many of the questions last week at our webinar on cloud computing were on data privacy issues. So we're delighted to follow so quickly with 2 speakers who are both so knowledgeable about data privacy on both sides of the Atlantic. So Justyna, if you'll go ahead and put the slides up, I'm going to say a few words about how the webinar works and introduce our speakers. I expect most of you have used Zoom before or a similar video conference platform, so you know about typing questions in the chat and posing them to our speakers. I will be asking the questions that I take from the chat. So in addition to the chat button, you'll see a participants button that now has 141 people on it. If you click on that, that lets you see the names of the people who are signed on. If you go to gallery view on your screen, you can also see the slides, or you can also see them in speaker view down the side. In addition to the interesting webinar and Q&A that will follow, you can use the participant list, the screen, and the screen names to replicate at least a bit of the networking a live event would provide. If you see a friend to whom you would like to send a greeting, you can send a private email in chat by hitting the drop down and switching from everyone to that person's name. So I encourage everyone to glance at the chat periodically and see if anyone has sent you a message. Unfortunately, the registration software we use does not recognize some Polish characters. Hence, we apologize if some letters in your name show up as question marks. When you register in the future, if you'll use just English letters, that'll avoid that problem. The session is being recorded, and the 60-minute webinar will be posted on CUA's YouTube channel within a few days. The series website links to those recordings. At the end of 60 minutes, I'll close the formal webinar and the recording will cease. Ms. Regan and Mr. Bonner graciously have agreed to stay on for up to another half hour so we can take more questions. I encourage those of you who would like to stay on for more questions and discussion. Justyna Regan, known to some of you also as Justyna Regan, will be our first speaker for 15 to 20 minutes. When she concludes, then I will also introduce both of them. I'm going to introduce Doug Bunner as well as a moment. You will notice in the chat that you will see longer bios to them, but I will just give a short introduction to each of them. Justyna Regan practices in the Chicago office of Miller Canfield, about which there's some information on this screen, specializing in Europe, US, and multinational business law, data privacy, intellectual property with particular expertise in software licensing, and cross-border defamation. She has a Master of Law, Ph.D., and habilitation degrees from University of Wrocław in Poland. She received a Fulbright Advanced Research Award for study in Chicago, Kent School of Law, and she was a visiting fellow at the Max Planck Institute in Hamburg, Germany. She is the chair of the Chicago Bar Association Cyber Law and Data Privacy Committee. She is admitted to the bar in Illinois and in Poland. When in Poland, she worked for the SPCG law firm. She took our International Business and Trade Law Summer Program twice, in both 2000 and 2004. And from that experience, she decided to complete the CUA-JU LL.M, which she did in 2005. Douglas Bonner is a partner in the Potomac Law Group in Washington, D.C. He has more than 25 years of experience representing wireline and wireless providers, cable television, voice over internet protocol providers, and broadcast companies in regulatory matters before the United States Federal Communications Commission, the Federal Trade Commission, the Department of Justice, the Department of Commerce, National Telecommunications and Information Administration, the Department of Transportation, National Highway Safety Administration, and other federal agencies, as well as in state regulatory proceedings and in telecommunications related litigation. His practice is focused in part on privacy and data security issues under US law and helping clients comply with the EU General Data Protection Regulation. He was co-chair of the Federal Communications Bar Association's Privacy and Data Security Committee for 3 years and has been recognized by Chambers USA as a leading lawyer in telecom, broadcast, and satellite. He is a 1983 JD graduate of the Columbus School of Law of the Catholic University of America, and he's a member of our law school's Board of Visitors. So Justyna, please begin. They have one slide deck that they've done together. So Justyna, when you're finished, Doug, you can just pick up and start to talk. So.
First and foremost, Professor Wortham, thank you so very much for putting this wonderful event together and for including me as one of the speakers. I am so unbelievably grateful for the opportunity, but first and foremost for being inspired by you for almost 20 years. So I'm really grateful. It has been a life-changing experience for me, which goes without saying because of my bio. And at the same time, I want to recognize and thank Professor Ludwikowski, who was the first one who gave me the chance. And again, I wouldn't be where I am if I wasn't the Catholic alumni. I also want to apologize for this first slide because instead of being it about the law firm that I am working for, it should have been about two of the speakers. So the responsibility is mine. It is my mistake, and please don't hold it against me. So my today's role is not that straightforward because I understand that almost 80, if not 90% of the attendees are Polish lawyers. So I wouldn't dare talk about the GDPR to professionals who are applying the GDPR on a daily basis. What I would like to focus on today, though, is explaining how the GDPR has been viewed and how it has been applied to the US companies and what kind of challenges it has posed to US companies when it comes to their compliance. When the GDPR was about to become effective, which was in May 2018, before that, my firm launched a series of 20 seminars for me. So I was going from one place to another, talking about the GDPR. And my first seminar was not that successful because what I was doing was I was just explaining and elaborating on European data privacy. And this is when I realized that my audience wasn't able to relate to what I was talking. And this is when I started thinking about the reason behind it. And the reason, I believe, is because of cultural and legal differences. So if you think about you as European lawyers, if you think about any kind of American, either lawyer or a friend of yours whom you have, if you think about something that you will never be able to agree on, the first thing that comes to my mind is the Second Amendment to US Constitution. Regardless of how many arguments I would have with my husband, when it comes to the roots of this law, he would never agree that what I am saying is right, because this is something that is running in the US DNA. This is what each and every American truly believes, that this is what they are entitled to. And this is our perspective. The same way as Americans believe that their constitutional right to bear arms is something that goes without saying, the same way we are perceiving data privacy protection. This is why when you are talking to your American counterparts, when you are talking to American professionals, this is why the GDPR basically doesn't click with them. They will be able to understand it. They will be able to apply it, but it will always be somehow forced on them. So it wouldn't come natural. The same way as for us, dealing with any kind of legal problem connected with or related with the Second Amendment, it would be a challenge because of the way we are wired. So when I started talking about the GDPR from this perspective to my audience, saying this is one of the biggest or one of the cultural differences that exists between US citizens and Europeans, because this is what we believe in. This is what we don't even need any kind of explanation for. This is when it became easier for me to talk about the GDPR and for my audience to be able to relate to what I was explaining, because they simply knew that this is something that they had to take for granted without trying to find any kind of justification, which for Americans would always be difficult to find. I won't be talking about the GDPR in general, because again, you know it probably even better than I do. But just so you understand, the GDPR became a big time topic at the beginning of 2019. This is when all those articles, and I'm not talking about law review articles, I am talking about articles in New York Times, Washington Post, like articles that were aimed at, that were targeting US business people. This is when the GDPR became of interest for a US audience. But they weren't explaining the GDPR right. They were only saying that the GDPR will start applying to US businesses. And then they were naturally and instantly jumping into fines and what kind of enforcement threats are behind the GDPR. And this is when my phone started ringing like several times a day, because US businesses or business owners started panicking, thinking that they will have to comply with the GDPR along the way, and that they will have to adhere to this weird new European law, or otherwise they will be exposed to very, very steep fines. But that's not actually the case. I believe that for you, most of you as Polish lawyers, you don't even think about applicability of the GDPR, because Article 3 in Section 1 is very obvious, saying if you are a EU controller or processor, the GDPR applies to you, goes without saying. But if you take a moment to read what Article 3.1 reads, you will see that it says that the GDPR applies to processing of personal data in the context of the EU establishment, regardless of where the processing takes place. So in other words, if a EU processor or controller if EU data is being processed anywhere outside of the EU in the context of that EU controller or processor, the GDPR will apply to that data. And when you look at the recital 22 of the GDPR doesn't actually help. So this is why we were all really waiting for some kind of guidelines, which we got from the European Data Protection Board on the territorial scope of the GDPR, but it wasn't that helpful. It was only saying that this context that Article 3.1 makes a reference to should have a very low threshold. So this is why, from our perspective, when it comes to our interpretation of Section 3.1, the rule of thumb is that whenever in doubt whether the GDPR applies, and whenever in doubt that there is a link that the processing is done in the context of EU processor or controller, you should always assume that the GDPR will apply to that data. So that's Section 3.1. Then what's really even more important for us is what Section 3.2 says. So you will see that 3.2 basically lists two circumstances when the GDPR will apply. So the first one is offering goods or services to individuals who are in the European Union. So again, if you are a non-EU controller and you are targeting, because for us in the context of Article 3.2a, this is the keyword. If a US business is actively targeting EU residents, that data that is collected as a result of that targeting will be governed by the GDPR. And there is so many misconceptions around that, because at first my clients or most of business owners thought that the GDPR will automatically attach to any data of, at first they were thinking EU citizens. So for instance, some of my clients were calling me saying, okay, we in the US, we are employing some people who are Polish or German citizens. Does it mean that their data should be governed by the GDPR? And the answer was very straightforward, no, because first and foremost, the GDPR doesn't recognize or applies regardless of citizenship. It applies, what matters is the place of residency. So individuals who are in the EU, who reside in the EU, and who are actively targeted. And when it comes to this actively targeting, the GDPR is trying to help. So in the recitals, you will see some explanation that targeting should be recognized or should take place regardless of whether there is any payment involved. So even if I am offering services for free, or even if I am targeting people as a part of my marketing campaign, the GDPR pursuant to the Section 3.2a will apply. But then the GDPR is trying to give us some additional factors that should guide us in determining whether the GDPR in this case will actually apply. And one of those factors is the language. So the GDPR says if a non-EU entity uses a language, one of the languages of the EU, when it comes to targeting EU residents, that could be a factor that should determine that Section 3.2a does actually apply. In the US, it's not actually helpful, because when it comes to English, it's contemporary Latin. Everyone uses English. When it comes to actively targeting EU residents using any other language, such as French, such as Spanish, again, doesn't help because of Mexico, because of Canada. So in the case of the US, that additional language factor is not actually helpful. Again, for us, the keyword is targeting. So the way I was explaining it to my clients, which some of them are European universities, if they have some programs that are designed for foreign students, including European students, obviously that would be actively targeting individuals. And in case those individuals happen to be in the EU when they were targeted, the GDPR will apply to their data. So this is the first circumstance from Article 3.2. The second one is monitoring behavior of individuals, again, individuals who are in the EU in case such behavior takes place in the EU. And the way we interpret, or the way this section is interpreted, it basically talks about tracking and using cookies. But we are talking here about, or we care about cookies that are actually collecting personal data and not data that only refers to functionality of the website. So if you are representing a US entity and that US entity is actively using cookies on its website, that data of EU residents, which was collected as a result of those cookies or through those cookies, will automatically be governed by the GDPR. Why? Because this is what Article 3.2b says. Two other circumstances that I listed on this slide. The first one refers to a case from 2014, which I always talk about because I simply find it interesting. Even though you will see that now this case or the language of that case is reflected in Article 3.1. So what happened in this Google Spain versus Google Inc. versus Agencia Española de Protección de Datos and Mr. Gonzalez, what happened was that Mr. Gonzalez is a Spanish citizen. And it happened that in 1998, his property was foreclosed, which means that it was seized because of his debts. And information about that foreclosure was published by the Spanish newspaper called La Valenciana, I believe. It was 1998. What happened was that in 2008, Mr. Gonzalez was still able to, when he was putting his last name on Google search, he was still, the link to that article was still popping up. So he contacted the publisher saying, it happened 11 years ago. I am at this point, I don't have any I'm not in any financial hardship. So why don't you remove it? And what the publisher responded was, I cannot remove it because it's not me who is processing your data, it's Google. So, which caused Mr. Gonzalez to contact Spanish Google saying, okay, so you are the one to blame. Please remove my name because I don't want my name to pop up in the search. And Google Spain did something that shouldn't have been done. So Google Spain basically turned to its parent company saying, it's not us, it's our US parent company. So they should be the one, they are the one who are in charge. And that was the case that was brought over before the European Court of Justice. And the European Court of Justice said, even though the Google Inc. as a US entity shouldn't fall or wouldn't have fallen into the scope of the prior directive, Spanish data privacy law, because of that processing that was done by the US entity, that processing was done in the context of the Spanish subsidiary. So as you can see, this is exactly the language that now we have in Article 3.1. So for you as lawyers, what I've been always telling my clients is that if you as a US entity have a subsidiary or an affiliate, a European subsidiary or a European affiliate, in case there is any processing that is done in the context of activities of that European counterpart, that processing or that data will be governed by the GDPR. And the very last instance or the last circumstance is when data is being processed through using of equipment that is located in the EU. Even though it doesn't happen that often, in practice, most of that equipment is actually located in the US. And even though this is the language that derives from the directive, I still believe that there is a way of interpreting Article 3.1 that processing happened in the context of a European entity in case equipment which was located in the EU was used. So those are actually 5 situations when the GDPR will apply. even though a controller or a processor is not an EU entity. It happens to be a US entity. So another problem or another challenge that my clients encountered was, what does it mean in practice? What does it mean to fall into the scope of the GDPR? Does it mean that all processing is automatically governed by the GDPR? In other words, does it mean that the GDPR attaches to all data? Of course it doesn't. So when a US entity realized or determined that some of its data was governed by the GDPR, its first step was doing a data audit. So this is what was happening in 2018 to determine which data actually is governed or will be governed by the GDPR once the GDPR becomes effective and which wasn't. And when it comes to that portion of data governed by the GDPR needed to be applied all along. So this is why when you look at privacy policies of US entities, those US entities who do fall or who are in possession or process data that falls into the GDPR, you will see sections which will be designed in order to comply with the GDPR. You will see that those entities appointed the EU representative, and even though at first that function, even though required by the GDPR, that requirement wasn't really complied with because there weren't many entities in the EU, who wanted to serve as EU representatives. At this point, there are many. There is insurance that they have in place, so this is why this requirement is complied with. And of course, it goes without saying, all DPAs, so my clients started receiving, before May 2018, started receiving data processing agreements to sign. So that data and would comply with the GDPR when it comes to Article 28. At the same time, I really believe that that was the moment which defined a future for European data privacy. This is when Americans realized that the data privacy is something that needs to be implemented, but this is something that Doug will be talking about at length in a few minutes. The very last thing that I want to talk about is transfer of data from the EU to the US. And again, I don't want to go into details because you know it, that there are three basic mechanisms within which data can be legally transferred or transferred pursuant to the GDPR. For us, what really matters from the US perspective was the adequacy decision, obviously, and contractual clauses. When it comes to the adequacy decisions, as you all know, at first we were all very happy before Schrems 1 judgment, because what was in place was a self-certification system. So US entities were declaring that they do comply, and this is why with safe harbor privacy, and this is how data could have been transferred from the EU to the US. What happened was that this status quo was disrupted or ended in October 2015 as a result of the first Schrems decision. I used to think that Schrem was a troublemaker, but recently someone told me that that's not actually the case. He was a very bright law student from Austria who loved data privacy and who, as the first person, started questioning this order that was in place. He started asking questions whether what was in place in the sense of data harbor framework was actually reflected all the changes that happened after 2001, because you have to know that a safe harbor privacy framework was developed between 1998 and 2002. And then after 2001, after September 11th, everything has changed. Everything in the sense of US agencies got acquired rights to carry on surveillance practices, which weren't in place before September 11. So they weren't in place when a safe harbor framework was adopted. So Mr. Schrems was the first one who started questioning whether what was adopted in 2000 was still current and up to date in 2015. And he raised that question based on Facebook transferring his data from Ireland to the US. So he lodged a complaint to the Irish Data Privacy Authority, and that complaint was dismissed because an Irish commissioner made a reference to a safe harbor framework saying that Mr. Schrems' data was transferred pursuant to that framework and thus was valid. And this is what prompted Mr. Schrems to start asking questions. And the Court of Justice agreed with him saying what basically Court of Justice said was that given that the safe harbor framework was adopted in 2000, at the time of its adoption, the US actually did have an adequate protection for data privacy, for data, adequate as compared to EU standards. But after September 11th, everything changed. And as of October 15th, that privacy framework that the US has isn't adequate anymore. So this is why, pursuant to the Schrems 1 decision, the safe harbor was invalidated. What was adopted in 2016 was EU-US Privacy Shield Framework, which was a little bit different because it wasn't a self-certificate. By adhering to that Privacy Shield framework, US entities didn't have to self-certify. They needed to register with the US authority, and they needed to declare that they comply. They needed to make certain documents and certain policies available and transparent. So much more accountability was adopted. We were very lucky to have that privacy field framework in place alive for 4 years, yet it was invalidated. It was invalidated on July 16th of this year, because the truth is that having that new framework in place hasn't changed much. Given the main criticism or the main argument that Mr. Schrems used in his Schrems 1 arguments. So still the same surveillance mechanisms were in place. The main attention was paid to Executive Order 1322 as well as Foreign Intelligence Surveillance Act. So all those bodies of public law that gave authorities to gain access to data, including European data, in case it was required for surveillance purposes. So this is why the Court of Justice invalidated the Privacy Shield framework in July 16 with no grace period. So it was invalidated instantly. What was actually probably even more important is that the court also took a look at contractual clauses, which is the second most common mechanism that is employed by US entities when it comes to receiving data from the EU. And even though for those of you who have used contractual clauses, you are fully aware that the language is a little bit awkward, and you always have to explain to your clients that even though this language doesn't read smooth, you cannot change anything because then those clauses wouldn't be enforceable. So the court paid some attention to the clauses and confirmed their validity with one really important caveat. So the court said that even though the clauses are still valid, because of their contractual nature, they are only valid between two parties. So this is why, in case of all those bodies of public law that allow surveillance or allow access to European data, contractual clauses doesn't actually mean much. So this is why the court said one additional thing. The court basically requested for both data controller and data processor to analyze the environment for those data, and in case they believe that that data isn't treated adequately, those parties should put some additional supplementary measures in place. And without those measures, a transfer should be invalidated. And this is all that was said. So those supplemental measures became a keyword for anyone who deals with data privacy, because we all started wondering what they should mean or what they should include. So that answer was fine. That question was finally answered a few days ago, because at the beginning of November, the first draft of recommendations was published, and those recommendations talk about supplemental measures, and they list supplemental measures that maybe, or first they identify when those supplemental measures will be required, and then they give certain examples of supplemental measures, putting them in different categories. But again, this is just a draft. So if anyone has any comments, now is the best time to raise them when it comes to those supplemental measures. So that was the most recent development, which was followed by the very last development, which was a new draft of contractual clauses. So that draft was published by the European Commission on November 16th. Again, this is just a draft, but what's really interesting is that those new contractual clauses, even though it's a draft, are composed or include center modules. So the way it will work in practice is that you will be basically customizing your contractual clauses depending on the circumstance or depending on the relationship that the parties are in. Again, at this point, now it's the best time to, if you have any comments, to submit them. And what's important from a legal or from a practical perspective is that once contractual clauses will finally be adopted, there will be a 1-year grace period. So your clients, those clients who rely on contractual clauses when it comes to their data transfer, won't have to instantly adopt new. They will have a year of a grace period to do so. Thank you so very much. Probably I have a feeling that my presentation was a little bit too long, so I'm very sorry about that. I appreciate the opportunity, and I will be available in the Q&A section. Thank you.
Oh, thank you, Justyna. And this is Doug Bonner. Justyna, that was an excellent presentation. So if you ran over a few minutes, no offense taken here at all. And I'm certain from the audience as well. I would also like to thank Professor Wortham for your leadership in organizing this speaker series and for inviting me to participate and present along with Justyna on this important topic and relevant topic of data privacy. Americans and Poles share many cultural, religious, and social ties, as you all know, which binds us together. And this, I think, event is just one example of those very close ties at work. I was particularly struck by Justyna's discussion early on about privacy principles being embraced by the European community as a whole. Perhaps that's as much a result of your 20th century history in Europe as anything, the oppression of Nazi and Stalin regime occupations of Poland, which are still painfully within memory, and the role of secret polices and oppressive governments. That's really influenced, I think, how Europeans think today about privacy and why the European community has tried so hard and made such strides in protecting individual rights. And we in the US, of course, we're a younger country, much younger country than yours. have not experienced that type of occupation and oppression in our history. And I think the British briefly burned down Washington, D.C., where I live, but they didn't occupy it for long. So we view privacy somewhat differently here in the U.S. We therefore don't understand an individual right to be forgotten as is protected in the GDPR, or recognized at least in the GDPR and in Europe. And so as Justyna rightly pointed out, the starting point of the DNA of the US view of privacy rights and is quite different from the European view. And that's probably the best, I think the first way to transition into a discussion of US privacy laws. And in our limited time today, I'm not going to even attempt to go over the entire landscape of US privacy laws, but what I thought I would focus on is the state of California, which has probably adopted the highest bar of privacy laws of any state in our country. And if you wonder why California is so important, it really bears mentioning that the California economy is not only the largest in the US, but it's also the 5th largest world economy. Just think of that. That's one of our 50 states. $3.2 trillion in gross state product in California, which ranks it ahead of India, the Indian economy, in South Asia, and just behind Germany's economy. So any company with any scale here in the US and many international companies operating in California obviously need to comply and be aware of and comply with these privacy laws, which apply to California residents in particular. But as we'll discuss, the implication of these privacy laws goes well beyond California residents. The California Consumer Privacy Act is the first of two statutes that I'm going to discuss. It's very recent in vintage. It became the statute itself became effective January 1, 2020. But the implementing regulations adopted by the California Attorney General only recently became effective a few months ago. They were the subject of comment. The California Attorney General, under this first statute, the California Consumer Privacy Act, the California Attorney General is empowered to adopt regulations under that statute and to enforce the statute. And after a comment period of about 8 to 9 months and approval by another California agency, the regulations became effective just in mid-August. And the CCPA is a disclosure law that provides a wide array of new rights for California residents to know what information. You refer to personal data under the GDPR. It's personal information under the California privacy law. They're somewhat similar in terms of their scope. You can see the definition on the slide there in terms of the scope of information it covers. Again, this is a defined term in the statute, but it does include browsing history, things like browsing history and geolocation data, which are treated. Some of which are treated with expanded protection under the more recent law, which we'll discuss. So the California, the CCPA, I'll use the acronym for short, does create this verifiable consumer request process, which allows California residents to submit a request to any business, and after the business does its due diligence and confirms the identity of the requesting party, it then has an obligation to respond to the request for information, or in addition to a disclosure right, potentially a request to delete personal information as well. Next slide, please. Oh, and finally, there's a do not sell right under the CCPA, allowing California residents to opt out of the sale of their personal information. And sale is not really sale is not literally defined as a commercial transaction type sale. It also includes, in a rather broad definition, the sharing of information with other parties. This is just this slide discusses the disclosure and deletion processes that I just mentioned. By the way, there are a couple of ways consumers can reach businesses and make these requests. They can either call, at a minimum, call a toll-free telephone number in the US, or by making a website request, or hitting a link on the business's website. One request is allowed for each consumer over any 12-month period, and covers the 12-month period preceding the request. So the law was effective January 1, 2020, and even though it was effective on that date, it still required businesses to begin adopting processes so that they could respond to consumer requests as of January 1, 2020, covering the entire 12-month period before that. So businesses had to set up IT processes and information storing processes so that they could effectively respond to requests beginning as of January 1 this year. Next slide, please. Okay, well, one of the first issues businesses have to confront in the U.S., and by the way, what qualifies as a business under the California statute? Well, it's either one of three criteria. To qualify, a business has to have annual gross revenues exceeding $25 million, or secondly, it collects the personal information of 50,000 or more consumers or households, or three, derives 50% or more of its annual revenues from selling consumer information, like a data mining company. And there are many of those in California, of course. Nonprofit companies are exempt. Nonprofit businesses are exempt from the statute, as are small businesses that don't meet any of those three criteria. And obviously, some of the initial questions that business needs to ask is: are they using or sharing personal information of California consumers with third parties or service providers? Service provider is a defined term under the CCPA for essentially a company, a third party company that processes personal information for the business. The statute provides for an exemption from the sale requirements of the statute if information is shared with a service provider pursuant to a written agreement, which includes essential terms such as limiting the use of the information by the service provider to only the express requirements of the business and as directed by the business. And if there is such an agreement compliant with the statute between the business and the service provider, the sharing of that information with the service provider is exempt from the do not sell requirements of the statute. Next slide, please. Enforcement of the CCPA, as I mentioned, is up to the California Attorney General. There is finding authority of up to $2,500 per violation, or $7,500 per intentional violation, and intentional would likely mean in the event, a second or third offense, of which the business has already been put on notice or received a warning or a fine previously. There is a mandatory 30-day period to cure a violation before the California Attorney General pursues enforcement or private action. So there is essentially an opportunity to cure a violation without facing that fine initially. And also parties or businesses can seek opinions of the Attorney General on how to comply with the statute under particular factual circumstances. The private right of action in the civil courts on behalf of individuals is limited to data breaches if you fail to meet reasonable security procedures. This tracks the reasonable security procedure requirement under the GDPR essentially. And there's a minimum statutory damage range of $100 to $750 per individual per incident. Many of our plaintiffs' bar lawyers here in the U.S. Have been eager to pursue this. I haven't heard of a lot of class action lawsuits yet because the statute's only recently been in effect, but I would expect to see, especially because of the statutory damage provision, future class actions being filed pursuant to this provision. Next slide. Here's a list of some best practices that we've advised our clients to follow. And I've seen them following many. This statute has required a lot of our clients to hire consultants, to help them map their data and store data for responding to verifiable requests, for example, from consumers. Mapping data is the first step to really determining what service provider agreements need to be negotiated. Excuse me. And determining what other contractual requirements you need to fulfill to bring your compliance up to date and make yourself fully compliant. Privacy policy revisions have been a big part of the CCPA compliance, not only including a do not sell my personal information link within the privacy policy, which is standard practice, but also making certain that you inform consumers about how you're using their personal information so that you comply with the notice provisions in the statute. Next slide. Okay, this webinar is very timely because not only just as businesses in California and businesses in the U.S. were getting up to speed and had finished implementing their processes, their IT processes to comply with the CCPA. Well, just this month, earlier this month, the California Privacy Rights Act, which has been dubbed CCPA 2.0, was approved in California on a referendum vote at the same time of our presidential election. It's not effective for at least a couple of years, but it's going to require, and it doesn't scuttle or eliminate the CCPA requirements, but it really builds upon them and expands them. It creates a new individual right to correction, which does not exist in the CCPA. It expands the scope of businesses that are subject to the law to include affiliates or subsidiaries that are subject to common control and branding. And that, you can imagine, I have a client that I've been representing and advising on the CCPA, and they're a tobacco products purveyor, and they operate under many different DBAs and affiliates, marketing to different customer segments. Well, and they shared information freely amongst their affiliates under the CCPA. Well, now they and many other companies, whether they're insurance conglomerates or selling alcoholic beverages or wine or whatever, if they're consumer facing, are now going to have to respond as a conglomerate, essentially, on behalf of their commonly controlled affiliates. And we'll know more once the regulations are adopted. There will be a rulemaking adopting rules to interpret the provisions of the statute before it becomes effective, which will likely be on July 1, 2013, at least when those regulations are effective. And from that point on, enforcement will likely occur of the CPRA. There's a new purpose limitation on the collection and use of personal information. Also a new category of sensitive personal information, which creates more or requires more limited use of that sensitive personal information category, which does include geolocation data, for example. Much of this new statute, you see essentially adopting far more data minimization use of personal information than existed under the CCPA. And data minimization, as you know well in Europe, is one of the key principles of the GDPR. The do not sell opt-out is now expanded to do not sell or share, addressing attempting obviously to address that ambiguity in the CCPA about do not sell my personal information, making clear that that instruction or opt-out applies to sharing as well. That needs to be posted on the business's internet homepage and include a link to limit the use of my sensitive personal information, which is the geolocation data I just mentioned, and other sensitive information like religion, et cetera. Next slide, please.
Doug?
Yes.
We've reached our 60 minutes, a little bit over. So we're going to
I'm just about done.
Great. We're going to continue to record till you're finished, and then we're going to close the recorded part, and we'll be answering the questions in the unrecorded part. So great.
Okay, great. Yeah, I'll rush through this last slide or two. There's a new consumer opt-out for behavioral advertising. This is going to be of great concern to the Facebooks and Googles of the world. This is in addition to the CCPA opt-out for do not sell my personal information. I'm sure this is going to be something that the major internet companies whose business models rely on behavioral advertising are going to be very concerned about and are going to be tracking very carefully in the rulemaking. There's also a contractor definition that's been added to service provider, which will also be subject to a written agreement. That will be decided. The scope of that additional categories is going to be decided in this next rulemaking. There's an exemption for employees of California businesses who are California residents. They will be exempt from compliance with the Act until January 1, 2023. And this is quite important for the first time ever, we now have a DPA in the US. We, like you in Europe, you're used to privacy regulators who do nothing but privacy enforcement. We've never had that in the US. Historically, we've all been about sectoral regulation for financial services or healthcare regulation, but we've never had a dedicated privacy enforcement agency that will adopt rules and enforce them. And this statute creates one called the California Privacy Protection Agency. It's going to be made up of 5 members, 2 appointed by the California governor, another by the Attorney General, and I think another by the Speaker of the House, and then the Senate, and the final 5th one by the Senate Rules Committee. And this agency will be responsible not just for the CPRA enforcement, but also the CCPA. But much will be determined by this upcoming rulemaking. I'm not going to go through these, all these. This would take far more time than we have, but here are some of the business requirements that will be businesses are going to have to look at to comply with the new statute. Obviously, negotiating new written contracts is a big part of it, revising and updating their IT systems to implement the new obligations, including responding to requests to correct personal information, identifying what sensitive personal information they hold, et cetera. Creating, obviously, establishing the opt-out for behavioral marketing, et cetera. So I think that's my last slide. Thank you for listening. Justyna and I will be happy to respond to your questions now.
Thank you so much. We've gone a few minutes over our 60, but the content was fabulous. And I think as we started dipping our toe into data privacy in last week's webinar, it's a very complex set of issues. So we well understand and appreciate and thank both of you for being willing to be speakers and sort of take us through this. And I think as you began, there's a lot of kind of differing perceptions on this issue on different sides of the Atlantic, and the 2 of you have done a great job of bridging that. We are going to cease the recorded part of this. We have 5 excellent questions already, and we might stay on just a tad over the full 90 minutes.